Hello, my name is Adrian Lively. I'm a disputes and risk partner at the law firm Osborne Clarke. I'm also a mediator. This is the second video in our series straight to the point of dispute resolution dealing with UK IP litigation. In the first video, we looked at the basic framework for UK IP litigation, and in this video, we want to look in a bit more detail about how that system works in practice for our clients. I have with me today, as I did for the first video, Arti Rajendra, who is Head of IP Disputes at Osborne Clarke. Arti, can I kick this off, please, by saying I'd like to really focus on what we discussed about IPEC and the shorter trial scheme. I think they're the most interesting areas because I want to take this as a comparison with the standard traditional litigation model we have for other types of litigation and see whether your model, if you like, the IP model is better. So should we start with IPEC? How does that work in practice? When is it good? What are the pros and cons?
So the IPEC is really designed for SMEs to give them access to justice. I think there was some concern before IPEC was launched that SMEs didn't really have the right forum to litigate their IP disputes. And the real benefit is the costs cap, which is £50,000, and that rarely ever gets ordered, that amount, to the winner. It's usually between £30,000 and £40,000. But it gives SMEs that comfort that their cost exposure isn't going to be too high. Also, the other thing about IPEC is the general rule is it's only known adverse documents that are disclosed. So you don't go through that massive disclosure exercise, which is costly and for a small company quite difficult to manage.
Because sometimes the cost and delay and sheer hassle of litigation can be a barrier to access to justice, especially for small clients, as you say, who have a lean legal budget, perhaps.
One of the other big benefits of IPEC is that you're guaranteed a specialist IP judge, so they will be completely up to speed on the latest authorities in IP law, and that will really cut down the time that it will take to do the trial itself, and the trial is limited to 2 days as well.
Well, IPEC sounds like a really good process to me for the smaller claims. It has limited costs and it's quick, and you get an expert tribunal in an IP judge. Let's look at larger cases, and we talked in our first video about the shorter trial scheme, which is for higher value cases, but is still relatively quick and efficient for the parties. Is that right?
Yeah, that's absolutely right. So in the shorter trial scheme, you usually have a trial within 12 months from issue of the claim form. You have a judgment that will be handed down 6 weeks thereafter, and you have summary assessment of costs, which is a massive advantage, and you don't have to do any cost budgeting at the beginning of the case either. So all of those are really well suited to IP cases, particularly also the sort of no or limited disclosure, because very rarely in IP cases is disclosure determinative of the issues. So, you know, the shorter trial scheme's been really well received. As I said, we've just done something there, and the clients were very happy with the process and the efficient way the case was dealt with.
Great. Well, that does sound like a very efficient system that you've outlined there for us. Thank you. But as with any system, does it suit everyone? Are there disadvantages? I mean, what's been the experience you've had advising our clients?
We would very often recommend the shorter trial scheme. I think where it is a disadvantage is if you're the defendant and you're being bounced into court on a really short timetable. I can see that being a concern. The other thing is, even though you've got a docketed judge, which means you get the same judge all the way through interim applications to the trial, it may not be a specialist IP judge, which you would obviously get in IPEC. The exception to that is if it's a patents case. If it's a patent case, then you would get one of the specialist patent court judges. but can still be done in under the shortest auspices of the shorter trial scheme.
Very good. So in terms of the overall scale of the activity in these areas, do you get a large volume of cases at IPEC level, because there are lots of small cases, and then of the larger cases, nearly all of them go through the shorter trial scheme system? Or how does it kind of work in terms of the numbers?
Yeah, it's not quite like that. I think IPEC has been a massive success, so they're really busy, lots of cases going through there, by SMEs and large corporations. Shorter trial scheme is doing really well. The big difference is that the highly complex patent cases, which really take up the majority of the court's time, don't fall in any of those two camps, and they have to be done under the usual High Court procedure. There is still streamlined disclosure in those cases, but they tend to require longer trials, and in some cases, depending on the technical complexity, even particular judges can only particular judges can hear them.
I think it's always the case that these massive cases, in a way, they give litigation a bad name because people hear about the long delays, they hear about the huge legal costs, and become fearful of litigation generally. And there's a good reason why those cases are as they are, but the vast majority of cases that our clients are involved in can be dealt with actually much more efficiently at these lower levels.
Yeah, I mean, there are absolutely, and in fact I'd probably say the vast majority of our work is for clients who are willing to spend an awful lot of money, because IP is absolutely central to their business, and that's just the way it is. But there is an alternative for other clients, and to use these more efficient, cost-effective routes to getting their disputes resolved.
Well, thank you, Artie. I hope that's given you some insight into the workings of UK IP litigation. Thank you for watching.